let's get into some specific rules now. This is 777. And you'll have your normal situation where when you file if you're a defense attorney, you entered your appearance. Simultaneously with entering your appearance with the court, you're supposed to make your demand for discovery with the state.
By the way, there are some attorneys who are still referring to 313.3 as opposed to 777. Under the scope rule, part 7, this is the only rule that applies for discovery in municipal court. It does not apply under 313.3. And the query should be, if an attorney makes a motion for discovery under rule 313.3, what should the court's response be, Mr. Ramsey?
Well, go to Superior Court. I mean, it's only been 10 years.
It would be within the court's province to dismiss that motion because they didn't cite the right rule.
Okay. So now what happens when there's a fight? Okay, there's been a demand for discovery, and the state thinks it's onerous, or there's been a demand for reciprocal discovery, and the defense has a problem with what the state wants. Rule 7:7-7E1 is the grounds you would use for protective order, okay? So go through here what you need to do. Look at all the things that, these are the reasons why you can get a protective order, okay? Privileges and things of that nature. So by way of motion, and I think we gave you an example in your materials, if there's a discovery issue, let's say for the state, and the defense asks for all kinds of crazy stuff. They want the officer's personnel file and baptismal certificate and all kinds of stuff like that. You would file a motion under this rule asking for protective order, claiming that it's not relevant to any particular issue in the case or for whatever relief the judge wants to give you. Also, with continuing duty to disclose issues, when there is a compliance with the discovery rule, you've got a continuing duty to supply that other individual with reciprocal discovery as things go on. If you don't get it, you can file an application for it, and this particular rule allows the judge to grant a continuance, prohibit the other party from introducing in evidence the material not disclosed, or enter such order as it deems appropriate, which could be for hollow sanctions, I would imagine.
Could be for dismissal of the case.
Or for dismissal. So what you would do is, if you have a situation where there was some residual discovery or continuing discovery you didn't get, and you're not getting it, or it's prejudicing you in some way, your motion for whatever relief you're looking for would be grounded by this rule, and this rule gives the judge the authority to take whatever actions appropriate under those circumstances. And I think we gave you an example of that in your materials. Okay. Now, there were significant changes on post-conviction relief applications that went into effect on September the 1st of last year. And we want to take a few minutes before we talk about the actual motions to discuss some of the background on these two types of applications you make in municipal court. And we have two different things we want to talk to you about. First is just the normal, run-of-the-mill post-conviction relief application. And then we want to compare and contrast that with LORIC applications. Now, start off with the proposition that the post-conviction relief application is the New Jersey equivalent of a petition for habeas corpus. It is a civil action. The civil rules apply, the civil burden of proof applies, okay? It's not supposed to be a substitute for direct appeal. Basically, you can't be raising things that could have been raised on direct appeal. If you are the proponent of one of these, you're the petitioner, and you go back in and you are successful, typically the relief that you're going to get is a vacating of the underlying conviction, and then the parties will be returned to their post-conviction status. Basically, the state will be left with an open case, which will either be prosecuted, plea bargain, dismissed, but will have some type of disposition associated with it.
Back to original plea of not guilty.
After original plea of not guilty, okay? But the relief that you're going to get if you're successful as a petitioner in a post-conviction relief application is that the underlying conviction is going to be gone, okay? And then something will happen to the case, dismissed, tried, re-plea bargained, whatever it may be. I want you to contrast this with a LORIC application. Now, in a LORIC application, your post-conviction relief is not geared toward vacating the prior conviction. Rather, what you're attempting to show is that the defendant was uncounseled at his prior conviction, and either one of two things. Number one, he was an indigent who would otherwise have qualified for public defender services or appointed counsel services, or alternatively, he was not indigent, but having had an attorney at the time would have made a big difference in his case. In other words, he pled guilty and maybe it was .09, or maybe he had two readings, a .09 and a .10, for example. Having had an attorney under those circumstances probably would have made a difference, especially back in the days when the per se level was .10. Now, if you're successful in a LORC application, what happens is that the prior conviction is kind of tossed out for purposes of enhancing the custodial component only of a future conviction for the same violation. Now, all of the case law dealing with LORC has come up in the context of drunk driving, but there's nothing to prevent this from being used in anything, like driving on the revoked list or shoplifting. I mean, anything where a prior conviction is going to enhance, a future sentence. And this comes up, in cases where prior convictions will trigger mandatory jail terms. Shoplifting and driving on the revoked list, the two that come to mind. There's probably plenty of others, and of course, drunk driving. So, let's say we have a situation where, the person has, this is his third offense, but you've been able to successfully attack one of the prior LORC, one of the prior convictions as uncounseled, and the defendant was not properly advised and was in indigence, let's say for the sake of argument. So that one goes out the window in terms of figuring out how much jail time the guy's going to get. If he's a third offender, he would lose his license for 10 years, get a $1,000 fine, but the jail part of the case would only be associated with the jail you could get for a second offense, which would be anywhere from minimum mandatory 2 days up to 90 days. Now, first thing I want you to understand is under 7:10-2, regular, good old American post-conviction relief, here's the rule, okay? This gives you all the basic stuff that you have to do. There's been an amendment to this rule which creates more specificity in terms of what you have to include in the petition. All right?
And this is a motion which deviates from Rule 771 because this requires a written motion to be made to the court of original jurisdiction wherein the action was first heard.
So start off with F. F is what tells you what you have to put in your moving papers. F2, this is the first thing that everybody screws up. The petition shall be verified by the defendant and set forth facts with specificity. So you have to file a verified petition here, okay? Then it's going to have to certify or swear to it at the end. You have to include all the stuff that's in here, in A, B, and C, the docket number, the sentence, whether there's any appellate proceedings and things of that nature, okay? You can actually incorporate that into the verified pleadings. So A, B, C, D, E, F is really kind of separate. And then G, this is new, capital G, because there was a lot of very loose practice going on around the state. So besides the moving papers in support of the application, you have to include, if it's available, records related to the underlying conviction, including but not limited to complaints, applications for the assignment of counsel, waiver, and transcripts of the defendant's first appearance. This will show what happened in court, what he was advised of. Entry of the plea of guilty and all the municipal court proceedings related to the conviction sought to be challenged. The petitioner shall account for the unavailability of records by way of written documentation from the municipal court administrator or custodian of records, as the case may be. That reference to custodian of records deals with police. So if you're in a situation where you should have been presenting some type of police report and the police don't have it anymore, you'd get a certification from the custodian of records for the police saying that it's not available anymore.
And this rule applies for either type of post-conviction relief petition you're filing, either under traditional where you're seeking to knock out the entire prior conviction or where you're just seeking to knock out the jail sentence for a third offense.